Ladies and gentlemen, can we just settle down quickly?
We can't hear you. I can't even hear you from here.
Really?
No.
Is it louder now, ma'am? Yes. Okay. Good afternoon, ladies and gentlemen, members of the media, colleagues. Thank you so much for braving the cold today to join us for this media briefing on the four legislative amendment bills that have been approved by Cabinet and form part of the Department of Justice and Constitutional Development's legislative program. Before we begin with today's proceedings, I would like to introduce our Minister for the Department of Justice and Constitutional Development, Honorable Mmamoloko Kubayi, who is joined by Deputy Minister and Mr. Andri Snell. We are also joined by our Acting Director General, Ms. Kalei Pillay. We also have with us our Acting Director General, our Acting Deputy Director General, Mr. Steve Ralekwa, as well as Advocate Sibele Mecha. Without any further ado, ladies and gentlemen, I think we're a little bit pressed for time. I would like to hand over to our Honorable Minister, who will take us through why we are here today. Thank you very much.
Thank you very much, Palisa. I'm not so sure what's happening with the audio today. I hope it's audible. Is it fine? It's fine. No. You can hear? Okay. It's sounding strange today. As Palisa has said, I'm joined by the Deputy Minister Andri Snell, Ms. Kalei Pillay, who substantially, this is her branch as the DDG, but currently acting as Director General, and then the two technical colleagues who are helping us in this legislation, Steve Ralekwa and CHC Malemeja. We are here to give update on four key legislation or legislative amendments that have been made in terms of the approval by Cabinet, the last Cabinet, and we are calling for public comments on three of them, and one which will be going into the National Assembly. And we thought it's important that we do this so that members of the public and our practitioners, but also those who are interested in these legislations, are able to follow. The first one is the legislation that deals, which is called the General Mining Laws Amendment Bill. The second one is the Legal Practice Amendment Bill. The third one is the Regulation of Trust Bill. These three ones are for public comments, which we have now published in our website and open for comments. Conspiracy, instigation, and incitement to commit offense bill is been approved by Cabinet, meant for us to introduce it in Parliament. And I'll go in terms of what these bills are meant. These amendments are aimed at strengthening South Africa's policy and legislative framework. The briefing will also cover the recently increased monetary jurisdiction of the small claims courts as part of ensuring there's access to justice for ordinary South Africans. Regularly reviewing and changing legislation ensures that laws remain fair, useful, and ensures equality before the law. It allows government to fix outdated rules, adapt to new technology, and to respond to changing social and political values. Without updates, laws can become inefficient, fail to protect citizens, or create legal confusion. As I deal with each bill, it will become clear how critical are these amendments. The General Mining Laws Amendment Bill, somebody will ask, why does justice have to do with this? It's because it's dealing particularly and it seeks to address the challenges that South Africa is experiencing in relation to illicit mining, in that While illicit mining is prohibited, illicit mining and the activities related to it are not a criminal offense. The term illicit mining and illegal mining are used interchangeably, and illicit mining, also commonly referred to as illegal mining, involves mining activities conducted without required permits, licenses, and statutory authorization from the government or relevant authorities such as those outlined in the Minerals and Petroleum Resources Development Act. Illegal miners, also commonly known as zamazamas, are illegal artisans or miners in South Africa who occupy closed or operational mines and conduct mining activities in search for minerals such as gold, amongst others, without proper authorization. That's why you'd hear Minister Mantashe will regularly say illegal mining is a criminal offense, not a mining activity. So this, we want to explain that we want to make it very clear that the bill does not seek to criminalize authorized artisan miners, meaning small-scale miners with permits from engaging in mining activities, so they will continue to operate as long as they have their permits. Illicit mining has negative effects on communities and in and around mining towns, damages the infrastructure of affected areas such as underground water pipes, which then affects water security, for example, and poses serious threat to safety and security of affected communities. And in many instances where we would have seen sinkholes creating and therefore providing such risk. So severe harm done to affected communities by illegal miners has increased due to illicit mining activities, and its illicit mining has become associated with kidnappings, human trafficking, child labor, and forced labor. And moreover, illegal mining gangs are directly involved in violent crimes associated with illegal firearms, rapes, murder, intimidation, housebreaking, theft, assault, corruption in those communities. So the bill seeks to amend various pieces of legislation with a view to amend provision dealing with offences and penalties, and to provide for matters connected therewith. The pieces of legislation that are being amended are the Criminal Procedure Act of 1977, the Diamonds Act of 1986, the Minerals and Petroleum Resources Development Act of 2002, and the Precious Metal Act of 2005. In terms of the statement, you'll have details in terms of what the clauses are actually being able to. What the CPA does in a nutshell, or the amendment there, it criminalizes now illicit or illegal mining, which previously it was not a criminal offense, but now it criminalizes it. And then the Diamond Act's amendments that are there are increasing penalties. You'll note there, we're moving from a fine of 250 to a fine of 100 million, and also moving from a 10 years of imprisonment to 30 years of imprisonment in terms of the amendment of Section 82A and B. And Section 82A, C and A also amends from a penalty, so it synchronizes because they were not aligned previously, where you would have had the minimum sentence would have been 4 years. So all of them actually, we're moving to imprisonment of 30 years. And then when you look at the MPRDA Act amendments, it gives you in terms of giving the definition in terms of artisanal mining, and that's the amendment there. But also on the MPRDA looks at what it prohibits in terms of illegal mining activities and prospecting, but also defines in terms of that what becomes the illegal prospecting, small scale mining permits. So those are the areas in terms of that, but also provides in that MPRDA amendment in terms of the definitions, which is a minor definition in terms of the boards. These details are on the statement as you receive it. You'll see in terms of what we are giving. Again, on the amendment of the MPRDA Act, you would have seen that previously it would only be inspectors that are doing inspections. We continue with that part of inspections, inspectors doing routine inspections, but insertion and empowering the SAPS to be able to carry compliance functions in this area of work. That's one of the areas that is also important to note in terms of the amendment. Again, you look in terms of the amendment on the MPRDA, is the clause that lists the contravention of the provision in terms of the offenses, but also prohibits individuals or person from prospecting, mining or exploring minerals and petroleum without proper authorization and notice to the landowner or lawful occupier in that area. Those are the issues that are required in terms of, or that are actually reflected in terms of the amendment. Another clause that is being amended is Section 9. You'd note that in the other area in terms of the penalties, we've reflected the penalty in terms of the Diamond Act. Again, on the MPRDA Act, we're reviewing the penalties that are reflected there in terms of illegal activities or illicit activities, from a fine of 100,000 to a fine not exceeding 100 million, and changing the imprisonment from 2 years to 30 years in terms of that when you contravene that act. So it's more in terms of increasing the steepness of the penalties and actually the years of sentencing. The second area of law amendment, or the bill that we are issuing out for public comments, which has been called in by many practitioners within our sector, is the Legal Practice Act, Amendment Act bill. The first area of amendment is in terms of the council, in terms of composition of the council that is being amended in that area, where it now talks about the order to allow for a decision of the council to be passed in situations where there are less than 12 members in terms of council. This for efficiency. Again, the bill in section 22 of the limitation that only an annual appropriation can be made by legal practitioners fidelity fund to allow for more than one appropriation in that, because it currently has a lacuna, and that lacuna currently is being closed for us to be able to allow for also in terms of, for example, it says that there is a current lacuna in the Act regarding the enabling provision for regulation to be made regarding the composition of the provincial councils, but also in terms of the amendment that is coming there to close that lacuna, requiring that the composition of the provincial councils should be done in terms of regulations, and giving the minister to be able to establish those and the composition thereof. And then the bill is explicit in terms of lawful authority to expand the list of qualifying community services activities through the regulations. This area as well is part of the work in terms of pro bono legal services and legal services rendered at either no fee and at a reduced fee. So the Act currently, the practitioners raised concerns about what is deemed as pro bono work and reduced fee, and therefore the amendments provides for a change in that and expands in the area of pro bono work in that area. Another area in terms of that, it's around the annual fees payable to council, where now the Act includes a new paragraph which seeks to enable the council to suspend a legal practitioner from the role of practicing legal practitioners for a continuous failure to pay annual levies and other fees payable to council. So this is what is due by practitioners so that they can be able to do what is required of them, and to enable the council to remove a person from the role of practicing or non-practicing legal practitioners upon receipt by the council of a court order cancelling that person's admission or striking that person from the role. This amendment entails that even non-practicing legal practitioners can be removed from the role upon receipt of a court order to that effect. For example, those who are in department, in for example, as who are attorneys are admitted in court but are not actively practicing daily but are legal practitioners. So this affects them as well. And then the other, it's which was previously in the Attorneys Act, a clause which was repealed, but then the lacuna existed. We bring it back into this act, which deals with the issues of advertising and touting by legal practitioners or people who end up exploiting communities in terms of work that can be done where it's reserved for legal practitioners. This is made illegal, and therefore it's brought back because we have seen that when the repeal happened, it left a gap, and therefore people continue to do this work that is not wanted. And then the other area, it's a proposal of an amendment to ensure that an appeal is lodged after a sanction has been imposed. The current wording of a subsection only allows an appeal against the finding of a disciplinary committee and not against both finding and sanction. So a legal practitioner can now, with this proposal, would be able to appeal both a finding and a sanction, because sometimes you find that the person maybe may agree with the finding but does not agree with the sanction being more severe, and therefore they can be able to appeal that, and that is brought in terms of that. But also there is an amendment in that area to provide that the council, when establishing an appeal tribunal for purposes of hearing appeals from disciplinary committees, must, where practicable, include at least one attorney, one advocate, and one layperson drawn by the council from a list of persons established and maintained by the Office of Ombuds. This is to ensure representation across the sector, and shouldn't be felt that it's a sector that belongs to another group and not another. The other amendment is in terms of the LPFF, which is liable to reimburse persons who suffered a loss as a result of theft only. The current amendments, so that we are able to ensure that where there is also negligence, there is liability. So it's not only refund, so that the trusts that are established by practitioners are able to cover for both negligence and also theft, because the current legislation only provides for theft, and this is to protect those who are receiving services. But what the Act does, or the proposal, it excludes LPFF from liability of transactions that take place in cryptocurrency. And the reason for this is because the violation of this currently are uncertain and therefore have not been included, but does not mean that in the future will not include them. The other clause that I want to speak to in terms of the work that is needed, it's the amendment to ensure that attorneys who are in the vast majority, who are responsible for the largest portion of trust accounts and contributes to LPFF, will be represented at board level, so that also, because they are practitioners, they are represented, so the board also will have indifferent representation in that regard. And that clause in terms of composition of the board is there. And also it also says after the election of the board, after the election of council, the board must be put in place within 6 months to avoid delays and therefore affect practitioners. The other clause is for ensuring that where there are complaints, the clauses insert the issue of reporting these complaints to South African Police Services, and also ensuring that criminal complaints are lodged in terms of claimants, because currently the conditions or the problem is that there will be complaints or people wanting to make sure that they claim in terms of their losses, but investigations of theft are not done properly, are compromised, because theft cases or cases in terms of theft have not been opened. So we are making it a compelling requirement for those cases to be opened. And then the other issue I want to speak to in terms of this, it's the granting of exemptions. The bill amends sections that authorizes the council to grant exemptions to a legal practitioner from completing a legal practice management course. The exemption may be full or partial on such conditions as may be appropriate. So this is one of the areas as well that is required. But also the bill amends sections of the Act to ensure that the practitioner pays all outstanding subscriptions and other fees, levies, and charges due to council before a fidelity fund certificate is being issued, so that there is compliance and as well ensuring that the sustainability of the Fidelity Association, the LPFF. Again, in terms of the amendments, the LPFF board is enabled to make rules regarding the recovery of trust interest that vest in the LPFF, to remove the discretion from the practitioner on the method of payment of interest to the board. I think the other area which is also important is the sections that amended in the Act to provide that a person who contravenes sections may not appear on behalf of a client, and that the council may apply for an interdict preventing such a legal practitioner from so appearing or rendering any legal service on behalf of a client. These provisions are currently only activated after convictions, and the section is amended to clarify who should protect the public before conviction. So if there's a complaint against a practitioner, therefore it means that this will kick in terms of representation. Then again, it provides for the regulation that the minister can make by insertion of a new paragraph consequently upon the amendment of this Act in terms of what needs to be coming, so that there's certainty in some of the work that needs to be done, so that it's not up to the minister just to insert, but it gives effect to say these are the areas of amendments that the minister must make. And then the other section that is quite critical in this is the amendment in terms of transitional provision in relation to qualification. There's been two applicants who brought an application to court, to the High Court, indicating that they obtained the degree of Bachelor's B Juris, I'm right, ne? B Proc. We call it B Proc. To call it fully, I might start entangling my tongue. So it's B Proc during 1997 to 1999, respectively, but now have difficulty in registering practical vocational training contracts, as Section 26, subsection 1 of the Act requires that the LLB degree for admission as an attorney. So this prejudices this individual, and we have agreed to that, and therefore the section is amended to ensure that they are not actually discriminated against, while we acknowledge that the BProc is no longer a qualification that is currently offered. So this area is also closed in terms of that. So you'll see in terms of those amendments full, where we are providing for the issues that needs to be dealt with. I think the last part which I want to speak to on this bill is that it amends sections of the Act that currently provides that a person who immediately before the date of commencement of the Act was entitled to be admitted and enrolled as an advocate, attorney, conveyancer, or notary is after that date entitled to be admitted and enrolled as such in terms of this Act. There was no clarity on what the date exactly is, and the matter was brought again to court for us to remedy this, and the Act does actually respond to that and provide for certainty and responding to that court judgment. The next area of the bill, as I said, the actual statement has details which Palisa will provide. I don't want to go into those details, but you'll have that, and the acts are already on the website. The bill, are already on the website for those who would want to see the details. The regulation of trust bill is another amendment or piece of legislation that we are amending, and quite critical. And the Trust Property Control Act of 1998 was enacted following a review of the Law of Trust by South African Law Reform Commission. The objective of the review was to address specific areas of the law of trust that were problematic and required legislative intervention at the time. In 38 years since the enactment, the Act has not been reviewed comprehensively, and therefore it means that there was a need for us to be able to regulate this and also change because the environment where the trusts are operating has significantly changed. The bill seeks to, amongst others, address shortcomings in the current legislation that enable trustees to evade accountability, where the Master of the High Court is constrained in exercising effective oversight over trust and do not provide adequate protection for beneficiaries, address the lack of transparency in the management and control of the trust property, which increases the risk of trust structures being misused for money laundering and other criminal activities. And this has been flagged during our exercise with the Financial Action Task Force. It's one of the areas for FATF for us to be able to improve, and therefore this amendment seeks to do that. What this bill seeks to do, firstly, is to protect the vulnerable person. It is commonly known or common practice by legal practitioners to request court to grant an order for creation of a trust to administer funds awarded as damages against, for example, road accident funds and for medical negligence of children or people with mental disability. There have been reports of trustees misappropriating these funds through excessive fees, improper investment, or outright misuse of the funds. The bill proposes such circumstances a court must, before granting an order for the creation of a trust, satisfy itself that a trust is an appropriate mechanism to hold the funds, the interest of the child or the person with a disability are adequately protected in the draft trust instrument. The draft trust instrument does not contain provision that may be detrimental to the child or the person who is a beneficiary, and the draft trust instrument makes provision for the remuneration of the trustee. So we control him because there are some reports that you find that some of the practitioners take more than 90% of the amounts that a person has been awarded in this regard. The Office of the Master of the High Court has received complaints, as I said, that trusts that were created as a vehicle to hold and manage land received through land reform programs are actually part of the issue, which is a problem. The complaints relate to the mismanagement and misappropriation of trust properties by trustees. The minister can only offer limited assistance to the affected beneficiaries due to the limited scope of the Act and the nature of the trust. The bill now proposes that trust should not be created to administer property received by any community from the state in terms of the agreement or in terms of any law. The objective is to ensure that the property in question is administered in terms of appropriate legislation that has been designed to afford adequate protection to the beneficiaries. This is one of the critical areas where we deal with community trusts in terms of land, especially your rural areas and in terms of the land redistribution program. The other area that the bill responds to is accountability by trustees and transparency in management and control of trust property. The lack of transparency in management and control of trust property creates a conducive environment for money laundering and other criminal activities. The bill contains provisions that are aimed at addressing this, including that trustees will be required to cause annual financial statements of trust to be prepared and to keep documents related to trust for the duration of their trusteeship and for a period of 5 years after they ceased to be trustees. Strengthening oversight over the Master's Office, the bill aims to improve provision in the Act that empowers the Master of the High Court to call upon trustees to account to the Master relating the administration and disposal of the trust properties, to appoint a person to investigate the trustees' administration and disposal of trust property. The bill empowers the Master to issue compliance notices and administrative fines for failure to comply in this regard. So the bill also makes provision for the filing of annual returns by trustees. Ensuring that compliance obligation imposes on trustees are appropriate to the objective of the bill. The bill legal framework for risk-based approach in the enforcement of the beneficial ownership register requirement. The master is required to cause a risk assessment to be conducted, and low-risk trust may be exempted from complying with beneficial ownership register requirements on the basis of the outcome of the risk assessment. The bill empowers the minister to exempt trust with no or minimum financial activity from preparing the annual financial statements. But currently, also, the Act actually provides that a trustee who fails to lodge a beneficial ownership register with the master of the High Court commits an offense. In this regard, we are proposing in terms of first notice of compliance before, and then administrative fine before actually criminal sanctions, which becomes our last resort. Offenses and penalties. The bill also provides for criminal offenses and penalties in respect of serious contraventions of this Act. The last bill that I want to talk to is the Conspiracy, Instigation and Incitement to Commit Offences Bill. The bill seeks to repeal the Righteous Assemblies Act of 1956. I think this one is one of those popular ones, which was originally designed to combat riotous gathering, publications, and conduct, and engendering hostility between one population group and the other. Others would know this as one of the apartheid legislation. The Act has been identified by the department as a piece of apartheid and colonial era legislation to be repealed or replaced. The Act also reminds the people of South Africa of the atrocities of the past which stand in the way of reconciliation in the country. Many provisions of this Act have been repealed, apart from the preamble and section 16, 17 and 18 of this Act. Only those clauses remain as we propose going towards Parliament. This section 16, it's relating to the special precautions in the interest of public safety regarding the explosives. This we have retained because it's one of those that is needed by law enforcement agencies to be able to carry their work. Section 17 of the Act deals with acts or conduct which constitute an incitement to public violence, where in terms of where you end up with public property destructions or loss of life. This actually we deemed it necessary to contain it because there isn't any clause that can be utilized by law enforcement agencies. And then section 18 of the Act deals with attempt, conspiracy and inducing another person to commit an offense. Here as well, it's an issue that relates to where you have an instigator for a public violence, but only those who have committed the act gets arrested, not the instigator being arrested. And this is one of the areas that is being retained and also reworked so that it complies with constitution or it complies with our constitution. So again, this act was taken to Concord, and the Concord declared sections of it being invalid and required, or being unconstitutional, and required Parliament to remedy these defects, and it was given 24 months, which we are late, but we are now making those amendments and ensuring that this act is actually in compliance with the Constitutional Court ruling, but also with our constitution in terms of new democracy, or in terms of our democratic principles, sorry. And then the last part of the statement I want to deal with is the Small Claims Court. The Small Claims Court provides a fast, affordable, and informal way to resolve minor civil dispute without using a lawyer. As of July 2026, the Department of Justice and Constitutional Development raised the monetary jurisdiction limit from 20,000 to 30,000. The Small Claims Court expands access to justice by making legal remedy easier for everyday citizens who cannot afford high litigation costs, and all official languages may be used in small claims court. We are actually doing an extensive review in this area to ensure that this is one of the areas that will actually make sure that we achieve our mandate as the department. Just as I close, with regards to the General Mining Laws Amendment Bill, the Legal Practice Amendment Bill, and the Regulation of Trust Bill, they have been gazetted for public comment. The full documents of the bills have been made available on our website since last week, Friday, the 7th August, and the closing date for submission to the department is 11 September 2026. The Conspiracy, Instigation, and Incitement to Commit Offence Bill has been approved by Cabinet as well and will be tabled to Parliament for processing and adoption. So we encourage all stakeholders, including civil society, businesses, labor, and members of the public, to participate in this process and provide inputs that will strengthen these important pieces of legislation as we continue to transform our society. Thank you.
Thank you very much, Minister. We will now take it to the floor and open it up for some questions. I'm looking at the time. May I just request that we take 5 questions from the floor and 5 questions online. Just a friendly reminder also to those asking questions, if you could kindly just introduce yourself, your name and your surname, as well as the media house that you represent. Thank you, colleagues. Are there any questions? I see one hand over there. Mmamoloko number 2. Is that it? Okay, I see 2 questions. The first gentleman.
Thank you very much. My name is Timo from SABC.
You can't hear at all. Are the mics not working? There's a mic behind. Is it Simo? Simo, behind you there's a mic on. Switch it off.
Can you hear me now? Thank you. It's Timo from SABC News. I just wanted to find out from the Minister in terms of the Riotous Assemblies Act, if maybe there are safeguards to ensure that political speech and activism is not actually misconstrued to be someone trying to, you know, instigate violence.
Thank you. Mmamoloko.
Good afternoon, Mmamoloko here from ENCA. I've got a couple of questions, maybe starting with the amendment relating to mining activity. I must admit that I have not read those bills, but I did not hear you speak to how the amendment bill is going to deal mainly with the supply chain routes. But also
the mining.
Yes, okay. In regard to mining, because these things are moving from point A to point B and they have a destination. But also related to that as well, how does the new bill speak to holding the kingpins accountable, because they definitely are not the ones who are digging. Also, I just want to understand if any of these bills were all of them were initiated by you as the executive arm of government, or you do have some coming from members in Parliament. And I just need clarity on particularly the section 18 subsection 2B of the Riotous Assemblies Act. As you correctly said, it was struck down by the Constitutional Court in 2022 in the matter of the EFF and the Minister of Professional Services. My question in that regard is, I think I heard you mentioning something that says you will have people who instigate violence, but those who are held accountable are those who commit the actual crime. How are you going to strike that balance between the Constitutional Court judgment that says that ruled in favor of the EFF to say that a provision was limiting freedom of expression with the concern you just mentioned, Minister? And lastly, related to that, when you say the conspiracy, instigation, and incitement to commit offense bill, is this one speaking to those that provision that has been struck off by the Constitutional Court? Because to me, as a lay person, it sounds as if they are similar. If you can just provide some clarity there. Thanks.
Thank you, colleagues. Because there's only two, is there an additional question? Okay, yeah. Okay. Thank you, Minister.
Thank you very much. It's offences, Timo, again.
Yes.
On illegal practitioners, I'd like to find out, especially on the issue of transformation, whether what concrete changes will the legal practice bill make to increase the participation of black legal practitioners, women and men.
Thank you. Abu Takalani, can we please check if there are any online questions? No online questions. That's fine. Thank you so much, colleagues. Minister, Deputy Minister. Thank you, DG.
I think DG will start.
Okay. Thank you.
Thank you very much for those questions. The current bill that we have is meant to address the provisions of the now unconstitutional act, which is the Writers' Assemblies Act. There's a very critical part about this bill which we still utilize in our prosecutions, which is about conspiracy and it's about instigation. So you will find all kinds of offences take place because some people are instigated by others to commit those offences or for whatever reason. So I think one needs to draw a line between what the Constitutional Court, what the Constitution provides for freedom of expression, and this new legislation is not intended to restrict freedom of expression because that is guaranteed in the Constitution, but it draws a very fine line between the criminality and those offences that are caused as a result of instigation. So you don't want people who instigate the crimes to walk away because they've instigated the crime, but they were not necessarily involved in the actual commission of the crime. So it talks to planning of the crimes, etc. So we have serious offences that are intended to be covered by this bill. And in fact, the court was very clear when it spoke about serious offences. They wanted us to define what a serious offence is and to be more clear, because the original bill was not clear, in the original act was not clear enough. So when one goes through the bill, you will find how we have defined serious offences, and there's a schedule in terms of what a serious offence is. That is in terms of the questions on political freedom freedom of expression and what this bill intends to do. Minister, would you like me to try the other questions as well, or just that one?
That's fine.
A very, very good afternoon to all. Thank you very much. I think just three key points. The one is that I think what the Minister has presented today forms part of a broader legislative program being driven by the Department of Justice and Constitutional Development. That legislative program seeks to give effect to the values and the injunctions of our Constitution. The 30th anniversary of its adoption we celebrate this year under the theme One Country, One Nation, Reflect, Renew, Recommit. It's quite an ambitious legislative program that deals with both the transformation of the legal profession and our legal system, as well as trying to tighten up our criminal law in order better to protect the people of South Africa. to answer directly to Offence's question, what is the transformative intent of the legislation, especially insofar as it pertains to black petitioners and in particular women and young people? I think one of the key elements in the legislation is, first of all, giving right of appearance to all legal practitioners, both attorneys and advocates, who have been admitted to practice. Previously, there were differential standards of experience required for attorneys to appear in different courts of our country, whereas those who had been admitted as advocates got automatic right of appearance in all courts of the country. So I think that alone is going to give black, women and young practitioners much greater access to appear in the highest courts of the land. The second issue that I wanted to touch upon, and now I'm asking a question to myself to answer on your behalf, that is the question of the small claims courts and the increase in the jurisdiction of small claims courts from 20,000 to 30,000 rand. That might appear to be a modest measure, but in terms of access to justice, especially for the poorest of the poor, that is a major step forward. And we would really urge yourselves as the media to assist us in communicating that message to as many people as possible. Small claims courts, as the Minister has said, are courts that function that are very accessible. They operate very often after hours. They are presided over by a commissioner who volunteers his or her service, can be an advocate, an attorney, a magistrate, an academic. The process is very simple. No lawyers are involved, and members of the public will receive assistance from the clerk of the small claims court to fill in the necessary documentation and be directed as to how to serve those papers. Once the case is heard, it is heard very often on a more informal basis, relying strongly also on the commissioner getting the two parties to talk and very often to reach agreements. The challenge that many litigants faced was that their claim exceeded 20,000 rand. And we've heard many stories of claimants who voluntarily sacrificed a part of their claim just in order to fall within the jurisdiction of the small claims court, which is faster and cheaper than other courts. So increasing that monetary jurisdiction up to 30,000 rand brings that the ease and the accessibility of the small claims court process within the reach of many more South Africans. Please assist us in communicating that good message. Thank you very much.
I think, okay. Thank you very much, colleagues. Just quick one. In terms of the legislation, I think it's Moloko. These are bills that are introduced by the executive, none of them from Parliament. And as DM said, we've got a very ambitious legislative program. And just to indicate, we introduced one bill which repeals 149 apartheid legislation in Parliament. So it has been tabled before Parliament as we speak. And the second bill that we are working on will also repeal 21 apartheid legislation. And then, because what we are doing, we're going on all legislative reform to look at all the laws that were under apartheid that have not been repealed, but also those that we would need to amend. They might have been established in apartheid but needed in the democratic government. But what we do, we look at their compliance with the Constitution and therefore amend to ensure that they are in line with the Constitution. And that's why we have this one. So I can safely say that's the work you'd see consistently will do that. And we took a decision that we must announce this one, because sometimes in legislative program, you find that the public get left behind. And if we just gazette them, and then without making public announcement properly as ministers, then they get not to know that these acts actually are coming to amendments or are coming into force or are being reviewed, and therefore they affect them. So I think that's what we want to communicate in terms of the work that we are doing. In terms of the mining amendments, the general mining amendment laws, what it means is that currently, whether you are a runner, you are a kingpin or anything, there is no law that defines or criminalizes or makes it an offense to be involved in illegal mining. So what we are starting with is that let's start and ensuring that actually there is an offense in terms of illegal mining. I remember at some point somebody was asking me that the Zamazamas have been arrested, and what the magistrate charged them with was actually in terms of violation of the migration laws, instead of being actually in the illegal activity. So it becomes difficult for the investigators to deal with this area of work, and this was proposed by NetJoins as part of what needed to respond to the challenges that they are facing when they do the operations and when they have to ensure success in terms of the work. So we believe that the fines, the conviction, are sufficient enough to deal with the entire value chain, and therefore also ensure conviction of all those who are involved. And once it's implemented, if there are gaps, we'll definitely look at amending. But from the inputs that we've received within the cabinet or government system, it has been said it's sufficient. We'll hear with the public, because it's going for public comments. If anyone finds with their expertise, finds that there's a gap, we'll look at those submissions, and that's why we are calling for those submissions in terms of this area of work. I think I must assure South Africans in two areas. One, that our commitment as a democratic state is to ensure that we comply with the Constitution. So we will not restrain any voice, will not go to make sure that we have legislation that will constrain the freedom of speech, the freedom of association, or any other freedoms, including political activity as a department and government. What we're simply making sure that, and that's why the DG was saying, we're ensuring that we comply with the Constitutional Court pronouncements, but also even including the issues of ensuring that we respond to what South Africans are calling for, because it's a two-way process. So I would want as well to call for South Africans to look at this act and also make their comments, but assurance is to be given to them that this Department of Justice in a democratic state cannot be the same as Department of Justice in apartheid time. So we do understand, that's why it's justice and constitutional development, because we are reminded consistently as the department that our job is also the promotion and development of our constitution. The other area as well in terms of the Legal Practice Act is to ensure that indeed feedback from practitioners, especially those who are previously disadvantaged, as DM has said, are actually catered for. But also we ensure that there's parity and respect for the profession, so that you don't have attorneys being disregarded or treated as if they are lesser important than advocates. So it brings those into the issue of community service as well, to assure that those who are practicing and are doing that, it's catered for. But also in terms of the governance bodies, so that everybody is also represented in the governance bodies. And lastly, to protect South Africans from those who have ill intentions, who actually are doing wrong things within the practice, so as practitioners. So the legislation is what is needed, is what has been called for. When I engage with practitioners, whether it's BLA, whether it's NADEL, whether it's LPC. This is what they've been asking for us to say, when are you releasing this legislation for us to actually close the gaps? So it does speak to what the sector, and especially those in previously disadvantaged communities, have been calling for. Thank you.
Thank you very much, Minister, Deputy Minister. I think, Mmamoloko, we will take one last question from the floor. Mmamoloko, and Abudu Ufenze. So we'll start with Mmamoloko and Abu.
Right. It's just to seek clarity here, Minister and Deputy Minister, to say, if my understanding is correct, the new bill of 2026, one that speaks on the one that the conspiracy, instigation and incitement to commit offences bill. Is my understanding correct that it seeks to revoke the Rioters Act in totality or parts of the Rioters Act? If you can speak to that. And on the other hand, the general mining bill, does it or does it not seek to, when it comes particularly to the Criminal Procedure Act, is it just adding on to give more teeth to the Criminal Procedure Act, or as you said, you are introducing a bill that will deal with over 100 and something apartheid laws? In that particular regard, is it just to add a provision, or it's the Criminal Procedure Act will be encompassed in this new bill? I hope I'm making sense.
Yeah, I can hear you. I'll answer. Thanks.
Okay.
Thank you very much for the opportunity. I just want to find out, will the department consider...
Hey, that mic is not audible. I don't know why. Maybe speak.
1, 2, 1, 2. Is much better?
Yeah, much better.
Okay. I'd like to find out if the department will consider increasing the small claims court limit in line with the inflation. And overall, how will the department measure whether these legislative reforms actually improve access to justice and not just simply create new laws on paper? Just the last one. On illegal mining, I just want to find out if maybe there could be specific powers given to law enforcement and prosecutors, or if it will just sort of increase punishment for perpetrators and include even the kingpins. Thank you.
Thank you. I'm Mmamoloko from UFM. Minister, just two areas, and this is not based on actual research, but from our own media reports, you get a sense that parolee are among the biggest offenders in terms of violent crimes. I know there's also people who are on bail, but I want to confine this question to parolees, whether you also have that information, whether your government is considering reviewing laws that allow people to get parole, in the sense of making it slightly more difficult to get parole. And secondly, you would be aware that in the Western Cape, there's a man that is calling for that province to, is calling for cessation, basically, and the response overwhelmingly from South Africans has been to say, but this is a British citizen wanting to break our country into pieces, and they've been calling on government actually to say, can't you deport or punish this man in a way? Is there a law that prevents people from doing such things as threatening the territorial integrity of the country, or sovereignty, if you wish?
Thank you. Are there no questions? Okay, thank you. We will now hand over to the Minister. Thank you.
I couldn't hear your name. The last speaker. And my Kgaugelo. Oh, no, thanks, Kgaugelo. Let me start with the questions that you have asked. Firstly, we separated justice from correctional services. So the Minister of Correctional Services, Minister Groenewald, will be the one that speaks on policy and legislative matters that relate to prisons, prisoners, and in that regard, including issues of parole. If I talk here, I'll be talking my common or my personal views, which are not, I don't think it will be appropriate in terms of that. Similarly, on deportation, it's immigration issues. Minister of Home Affairs will do, but just broadly on constitutionality of issues, the cessation can be supported. We are one in terms of the constitution. We talk about one nation, we talk about one country. We are not even in terms of, we have single state, not different or federal states as the republic, and that's what the constitution calls for, and for all of us to respect that in terms of our constitutional requirements. The nationality and other things can be dealt with by the relevant minister. The two issues raised by colleagues from SABC and ENCA, I think, let me explain. That's why we call it general laws. So it's amending various pieces of legislation, but it doesn't amend overall, for example, the mining. So it goes to that act, goes to a particular section. So when you look at the statement, it will tell you that you are amending this section. So it will amend that. So with criminal procedure, it's not the amendment of the entirety of criminal procedure. So we're going into the criminal procedure, inserting illegal mining or illicit mining as a criminal offense, because currently is not listed under the schedules of offenses. So that's what it means. I do note that many South Africans have been calling for the review of Criminal Procedure Act, and we've been committing as the department that we will review the criminal procedure, not only communities, but practitioners. This project was given to the law reform. They've been working on it. As the department, we are working. We hopefully that we'll be able to conclude this work, because it's one piece of legislation that is critical. We take a serious beating from our own colleagues in cabinet, especially within the JCPS cluster, in terms of the time it took the department to amend this legislation. So we will come to the public as soon as possible to announce in terms of what we are doing with the Criminal Procedure Act. The bill also, in terms of the General Laws Amendment, it's not only increasing the penalties, it's amending various areas, as I said, criminal procedure. It amends the Diamond Act, it amends the MPRDA, and amends the others, petroleum. But in the process as well, in terms of law enforcement agencies, it does give SABS powers in terms of these amendments that we are bringing forth. So it's bringing that in terms of the work that needs to be done, and also, as I say, it's proposals from JCPS, especially net joints, after operation from technical point, that they saw that there is limitation or constraints in terms of SABS. And you'd remember, others would argue that SABS is very constrained. There's only one law enforcement. SABS is the only authority in terms of enforcing the law in the country, and that's why they've got to have, because once it's classified as a criminal offense, then it gives SABS a role to play, and that's why they're coming in into being able to play in that space. I hope I've been able to answer all the questions.
The Rioters Act, is it being done away in totality?
Pardon?
The Rioters Act.
Oh, yes. The Rioters Act, it's what I've said is that we've removed what you'd see with a new bill. It removes all the other clauses. It remains with what now, all what we have deemed as, we didn't repeal it, because once we repeal it, it ceases to exist. So we are amending it, giving it a new name, and then again, remaining with clauses that we've called about 4 or 5 clauses that are remaining, which are critical for us to remain with. So the entirety of that act will not exist, and it will be a new one under a new name with those clauses that we are bringing. So we could have safely said we repealing and creating, but we thought that it will complicate from a technical and legal process point of view, and that's why we had to do it in that way. It's what is required as well by Parliament. Otherwise, you create a gap, because once you repeal, you can't repeal and introduce at the same time. And then we understood that there will be a lacuna if we repeal while we need certain clauses in those acts that needed to. Those ones that we didn't have, the ones that are called, I announced about 149. Those ones, none of the clauses we need. So we're repealing those acts. Or some of them you find that there's a new act that is actually has been put in place in the democratic South Africa, and therefore it's easy for us to actually repeal it completely in terms of that old act. Thank you very much.
Thank you, Minister. Thank you, Deputy Minister, DDG, Advocate Sibelemecha. That, ladies and gentlemen, concludes our media briefing for today. We'd just like to take this opportunity to thank you all for availing yourselves, and have a great day. Thank you. Ma'am?
and Steve must take interviews. Oh, okay. They are my technical
Will do, ma'am. Thank you.
Sorry, engele desa nyana mo. Sorry, engele desa nyana. Kono to mo. Yeah.